It's a great pleasure to welcome everyone to the last Young Scholars series for this semester. Angela is going to talk to us about impeaching judges. This is part of her PhD, which focuses on the impeachment of the Chief Justices in the Philippines a few years ago, and the Chief Justice in Sri Lanka, on Peru, also a few years ago. In terms of the impeachment of Chief Justice Corona of the Philippines, Angela has some sort of interest in the matter because she used to work for Chief Justice Corona, and she has very fond memories of him. And from our conversations, I think that she believes that he was perhaps unfairly treated. Chief Justice Corona just passed away a few weeks ago, so to some extent, this talk is in his memory.
Yes.
Yes, because I believe Angela regards the Chief Justice as, although he was found guilty of corruption in terms of tax, I believe, or declarations of his earnings, she believes that he was nonetheless a very respected Chief Justice, nonetheless. She will look into the process of impeaching Chief Justices and some of the political implications of that, especially as used in modern day times. Angela.
So, good afternoon. My paper is entitled Enforcing Political Accountability for the Decisional Independence of Appointed Judges. So I will start with my thesis statement, which is enforcing judicial accountability premised on alleged abuse of decisional independence generally leads to proceedings characterized by violations of the respondent judge's fundamental rights, thus necessitating an international mechanism of simultaneously protecting individual rights of those judges and judicial independence. The scope of my study is that I would be discussing the effects of judicialization of politics on inter-branch relations in government, the relationship of judicial independence and judicial accountability, and the use of impeachment proceedings as a mechanism to enforce judicial accountability. The limitations are that it basically focuses on the Philippines and Sri Lanka, although I will be discussing other jurisdictions, and my perspective is largely Anglo-American. The objectives of my presentation are the following. The first one is to illustrate how judicialization of politics strains inter-branch relations, to establish the imbalance between the mechanisms of judicial independence and enforcement mechanisms of judicial accountability. In particular, I argue that the lack of a universal definition for judicial accountability is very much open to abuse, and finally to show how impeachment may be systematically abused to capture the judiciary. The structure of my presentation, again, I start with the judicialization of politics and then the relationship between judicial independence and judicial accountability, with particular interest to Burbach's agency theory of judicial accountability, which I will discuss later, and lastly are my case studies and observations. So this is our traditional conception of government. The executive implements the laws, the legislative creates laws, and the judiciary resolves disputes arising from the application of laws. With judicialization of politics, the court is actually given the power of judicial review. What does this mean? The doctrine of constitutional supremacy clothes the courts or the judiciary with the power to check on the actions of the executive and the legislative, and therefore, in a certain way, it interferes with the discharge of the duties of the executives and the members of parliament or Congress. So here, as you will see, the purple circle represents the power of judicial review. It, in a way, encompasses the functions of the legislative and the executive, but only to the extent of determining whether their actions are consistent with the mandate of the Constitution. There are certain instances, if you could see the red arrows, these stand for institutional attacks against the court. It is a way of retaliating by the executive and the legislative to express its discontent with, for instance, a decision of the court in the construction of a particular provision of law, which they think has unfairly interfered with their functions. According to Ginsburg, for the court to avoid an institutional attack, what is necessary is that courts act in a strategic manner and observe tolerance zones. But I think that if a court has to observe these tolerance zones or to act strategically, there would necessarily be some areas that the court would not be touching on. Therefore, it limits the power of judicial review and therefore curtails judicial independence. So judicial independence and accountability are complementary terms. When we talk of judicial independence, it actually means the lack of interference in the discharge of court functions. So the UN Basic Principle defines it in this way: the principle of judicial independence of the judiciary entitles and requires the judiciary to ensure that judicial proceedings are conducted fairly and that the rights of the parties are respected. It has two aspects, basically the individual independence of judges and the institutional autonomy of the courts. What this paper is primarily interested in is the decisional independence of judges. Judges should be free from any fear of reprisal whenever they decide cases, and that they should only be guided by law and their conscience. Judicial accountability, on the other hand, is not specifically defined in any international instrument. In fact, there is just one, the Latimer House Principles, that actually uses the terms. But there are a lot of limitations imposed, and today I'm using the UN Basic Principles. Basically, the other instruments follow this. There are certain limitations on how you can impose judicial accountability on judges. For instance, a judge who is facing an administrative action is entitled to the right to fair trial, that he or she could only be suspended or removed for a cause. And the third one, it says that in recognition of the fact that an impeachment proceeding is largely political, there should be no independent review of decisions by impeachment courts or tribunals. So, what is impeachment? Impeachment is actually a mechanism that originated from the English Parliament, by which Parliament holds ministers appointed by the Crown liable to it. Today, it is largely associated with the removal of corrupt public officials, in this case judges, from their position. There is a rule with respect to judges as accountable officers, and that is that judges could not be held accountable for wrong or erroneous decisions unless the error was committed with manifest bad faith or corruption. In my survey of cases, I have come across numerous instances of impeachment, but very few actually involve the exercise of decisional independence. Basically, I was only able to isolate 4 as of this January, which are Malaysia, Peru, the Philippines, and Sri Lanka. In Malaysia and Peru, there was only one impeachment. So these are my observations basically from the trials that took place in those jurisdictions. The first one is that they were removed for vague reasons, and they were impeached for very vague reasons, and the reasons for their removal were actually poorly explained. In Malaysia, the 1988 constitutional crisis resulted in the removal of the Lord President of the Malaysian Supreme Court. But what happened before that was that Mahathir, in a 1988 Time magazine interview, actually said that he was resenting the fact that the judiciary was checking on executive action, and that the court had its own right to interpret the Constitution, and the executive has its own right to interpret the Constitution for the purpose of enforcement, and the court should actually stick to its job so the executive could stick to its job. So basically that was the argument of Mahathir. There were a series of cases wherein the Malaysian Supreme Court nullified actions of the Malaysian executive. So this heightened into a controversy involving the election of the then Prime Minister Mahathir Mohamad as president of the UNO. And when Mahathir was being threatened with the result of the outcome of the case in UNO, that was when he actually moved formally to impeach the Lord President. In the case of Peru, there was what they called the interpretation law case, wherein the allies of Fujimori wanted him to run for a third term. So they come up with a way to amend the constitution, and an action was filed in the Constitutional Court of Peru asking a particular how a particular provision of the Constitution should be interpreted, but the Constitutional Court ended up in a deadlock such that there was no interpretation of the provision, and the implication of this was that Fujimori would not be able to run for a second term, for a third term or a second re-election. And so during that time, there were papers that were lost in the offices of some of the justices, and a committee in Congress was asked to investigate. But there was no findings with respect to how those papers were lost, but they instead found grounds to impeach the 3 justices who lost papers on the ground that these justices circulated a working paper, misrepresenting that the working paper was already a deliberated decision. So the working paper, which is a draft of the decision, looked like an actual decision. So they said that this constituted a usurpation of court functions, and so they impeached these 3 justices. A private investigation was conducted by another committee in Congress, and a recommendation was submitted to the National Congress, and on the same day they voted to remove the justices. So there was also a disregard of the fundamental rights of the respondent judges. There was no fair trial. In the case of the Malaysian Prime Minister, actually, he asked the court for an injunction to stop the hearing because he wanted a public trial, but the public trial was denied. That's why he went to the High Court. But the High Court refused to rule on the matter, such that he was forced actually to go to the Supreme Court, and the Supreme Court ruled in his favor. But the court wasn't able to serve a copy of the injunction because the committee hid in the Parliament building and forwarded its recommendation to the Malaysian king, and the next thing was that he was impeached. But it did not stop there. The justices who ruled in favor of the Lord President were also impeached. So Malaysia ended up with 6 impeached justices in a matter of days. In Peru, the same thing happened. The recommendation was given on the same day, and they were impeached on the same day. So there really was no due process in that sense. There was also an lack of effective domestic mechanisms for redress, or none at all. In Malaysia, obviously, there was nothing more to do if you rule in favor of the Chief Justice or you rule against the leading party, which was UNO, then you just get impeached. In Peru, the justices were able to file writs of amparo locally, but all these were not resolved because the courts of ordinary jurisdiction actually just slept on the cases. And so when they went to the Inter-American Court of Human Rights, it was one of the considerations that there was a failure of the domestic mechanism, so they assumed jurisdiction over the matter.
Could I just ask you to clarify? You referred to writs of amparo. That's a civil law
yes, I'm sorry.
application. That's very common in Latin America and in the Philippines. What exactly are writs of amparo?
The writ of amparo in civil countries is actually similar to the petition for judicial review in a common law country. So it's basically an adjudication of whether the fundamental rights of the complainant or the petitioner was violated, or there was a threat of it being violated.
So the judges put out such writs in Peru, but they were simply ignored.
No, no writs were ever issued. The justices of the ordinary courts just slept on the cases. So it was just there, languishing in the courts. So basically, this is my research gap. How can the judiciary be protected against abuse? Oh, I'm sorry. Oops. Okay. With respect to the domestic mechanisms of independent review, there is actually a conflict in international law. Because as I mentioned earlier, the Inter-American Court of Human Rights assumed jurisdiction over the case of Peru, but you also have the UN Basic Principles, which I mentioned earlier, which clearly says there cannot be any independent review. You also have varying state practices. Nixon versus the United States says that because the power of impeachment was solely given to the Senate, courts cannot review impeachment proceedings or impeachment decisions. But you also have Pakistan, wherein the court said that an affront against the Chief Justice is an affront to judicial independence, therefore a matter of public interest, which the court could take cognizance of. So there's a confusion with that matter. So again, my thesis, my research gap is that how can the judiciary be protected against the abuse of impeachment proceedings as a means of enforcing judicial accountability, and specifically, are the fundamental rights of respondent judges facing impeachment amply protected? There is this notion that because impeachment proceedings are political in nature, anything is fair game, and that was one of the problems in the Philippines when one of the senators actually stood up and said he does not have human rights because he's a public figure, and then you have other senators closing in on him and saying it could not be that way, he still has human rights. Unfortunately, I couldn't find the video of that, and it was 45 minutes. So here, the Chief Justices on trial. So the agency theory of judicial accountability holds that it views judges as a means to an end. So a judge who fails to fulfill his commitment to support the policies of the appointing power should be held accountable and removed. Being held accountable would mean that the judge would be removed from office and substituted with a friendlier judge to create a more cooperative court. So I chose the Philippines and Sri Lanka because there have been 2 impeachment trials within roughly 1 decade. So in the Philippines, we had Chief Justice Hilario Davina in 2003. He was appointed by then President Estrada in 1998, and an impeachment complaint was filed against him by the deposed Estrada with the help of the opposition in Congress. And in 2002, we had another one with Renato Corona, who was appointed by Arroyo in 2010 and impeached and removed from office by an Aquino-allied Congress in 2012. In Sri Lanka, we also had 2. The first one was Sarath Silva in 2001. He was appointed by Chandrika Kamaratunga in 1995, and the opposition announced plans to impeach him in 2001. And in 2013, there was Shirani Bandaranayake, who was appointed by Rajapaksa in 2011 and then impeached and removed from office by a Rajapaksa-led parliament. So when Bandaranayake was impeached, the president was Rajapaksa and his brother was Speaker of Parliament. So the impeachment proceedings that resulted in the dismissal of the impeachment complaint. The impeachment of Davina was based on the mismanagement the alleged mismanagement of the Judiciary Development Fund. But the side story, according to the people, was that Davina was appointed by Estrada, but he was the justice who swore in Gloria Macapagal Arroyo in 2001 after the protest, the 3-day protest against Estrada, after the walkout during the his impeachment trial in 2001, and the decision of Estrada versus Arroyo, wherein the court upheld the swearing in of Arroyo as president of the Philippines, despite the absence of a clear ground on Estrada's resignation. Was it a resignation or abandonment of office? It was really unclear. But still, they said that, well, Arroyo has sworn in, so she's president. He left the palace anyway. What is significant about this impeachment was the Francisco decision. Prior to the impeachment of Davina, the standing rule in the Philippines was that impeachment proceedings could not be judicially reviewed because of the political question doctrine. This was a case under the 1973 Constitution involving the impeachment of former President Ferdinand Marcos before he was toppled in 1986. The Francisco decision abandoned this rule and said that the 1987 Constitution expanded the concept or the scope of judicial power to include judicial review. The court was empowered to determine whether or not a particular branch or office of government acted with grave abuse of discretion, amounting to lack or excess of jurisdiction. So that is basically a ground for judicial review. And they said that anything now could be reviewed by the court if there is proof that there was a violation or there could be a violation of fundamental rights. The case was eventually dismissed because Arroyo lobbied for it in Congress, asking her allies in Congress for national unity. On the other hand, in Sri Lanka, we have Silva. The supposed grounds for his impeachment would have been arbitrary and unlawful acts, because it was said that he was dismissing judges without any reason or trial. So there was a violation of due process on his part. The side story was that this was near the time of the Sri Lankan Civil War, and there was an executive-legislative power struggle. The president and the prime minister could not see eye to eye. So the reason for the impeachment complaint not going through Parliament was that the president exercised her prerogative to dissolve Parliament within 1 year after the election. Under the Sri Lankan Constitution, the government should be one of consensus, and if the president and the prime minister could not agree on policies, then the president could dissolve Parliament on specific grounds. So that was what happened when the mistake here, I think, of the members of Parliament was to go to media and tell them that we are impeaching the Chief Justice. So it gave time for the President to exercise the prerogative. So now the ones that resulted in the removal from office. So Corona was impeached on 8 grounds. They were supposed to constitute the betrayal of public trust, culpable violation of the Constitution, and suspicions of graft and corruption. But if you examine the impeachment complaint, 6 out of the 8 acts actually constituted collegiate acts of the court. In particular, this involved the failure of the court to impose a more serious penalty on Justice Mariana del Castillo for plagiarizing several treatises. There were flip-flopping decisions of the court and several public interest issues, such as the League of Cities, which involved gerrymandering, and the labor rights of the flight attendants of the Philippine Airlines. There was, again, the mismanagement of the Judicial Development Fund, which over time has become something of a big issue between the legislative and the judiciary in the Philippines. The side story with Corona was that Aquino always branded him as a midnight appointee. So there was a standing case in the Philippines known as Inre, Valenzuela, and Vallarta, which said that no appointments could be made during the election ban. But Inre, Valenzuela, and Vallarta was actually an inquiry by the Office of the Chief Justice and the Judicial and Bar Council to the court and bank on what they would do with assigned appointments of 2 judges and the list of 3 nominees for the Court of Appeals. So there was a vacancy in the Court of Appeals, and they were asking whether they should already forward the list of nominees for the president to allow him to appoint a new justice. But the court said that, well, we should give courtesy to the next president, so the judges were asked to defer the oath-taking, and the JBSC was asked to hold on to the list of 3 nominees. But in 2010, the Supreme Court came up with a new decision, De Castro versus the Judicial and Bar Council, saying explicitly that the election ban contained in the article on the executive only covered the executive and would not pertain to appointments in the judiciary. And the second story was Hacienda Luisita. Aquino did not like particularly Corona, but I think he would dislike the entire court when the court ordered the distribution of their family's 6,500 hectare property known as Hacienda Luisita, which is a vast sugar land. So the court ordered its distribution to the tenant farmers pursuant to the Comprehensive Agrarian Reform Program of the government. A couple of days after the decision on Hacienda Luisita came the impeachment complaint, and the rest, as they say, was history. There was a 43-day trial, which resembled it was more of a circus, but sometimes it was also like a gag show. It was characterized by prejudicial publicity, with most of the evidence being presented to media before it could actually be authenticated in court. And whenever the prosecution would be asked where they got the documents, because a lot of the documents were eventually found to be spurious, and the purported sources would actually say that the documents are a forgery and that did not come from us, and they would be giving an actual form coming from, say, the bank versus the one that the prosecution has presented to court. So when asked where they got these papers, it would usually be said, well, a little lady handed it to me in the hotel lobby, or somebody left a bag, a mysterious messenger left a bag on my gate containing these papers. Another important thing about the Corona impeachment trial was that the depository banks of the Chief Justice went to the Supreme Court and asked for an injunction against a subpoena issued to them to bring documents pertaining to the bank accounts of the Chief Justice, and the court granted it because under Philippine law, all foreign currency deposits are absolutely confidential. So Senate voted in favor of respecting this order, but again, there was an episode right out of a soap opera where the defense team stands up and says, we have news that the executive is bribing the senators to disrespect the order, and the senators say, well, that's imputing bad faith on us. And then it takes a long time, but the Senate eventually resolves to respect the order. But eventually, a year later, one of the senators would actually say in a privileged speech that, yes, we did receive 50 million pesos. That's roughly $1 million in exchange for impeaching him, and now they're persecuting us. So it's another Supreme Court case entitled well, anyway, it's another Supreme Court case, but there hasn't been any investigation yet on that matter. And then Corona was removed from office due to his failure to disclose his US dollar accounts in his statement of assets, liabilities, and net worth. Despite the fact that he raised a legal defense, because there are two conflicting laws in the Philippines. First was that, as I mentioned earlier, the absolute confidentiality of foreign currency deposits, and the other one is the obligation to disclose all assets and liabilities in a particular statement. Corona was saying that my understanding is that the Foreign Currency Deposits Act is more specific, so I followed that and I did not disclose. But the senators are saying that, no, you're a public official, so you should follow the law on public officers because it's more specific to you. So, anyway, they just couldn't agree on the interpretation and which should take precedence over the other. In Bandaranaike's case, she was impeached on grounds of graft and corruption, alleged bias, and abuse of authority. The side story is the Davina Ghuma bill. What is this bill? The bill actually concentrates the power on the Rajapaksa family. At the time Bandaranaike was impeached, as I mentioned earlier, the president was a Rajapaksa, the Speaker of Parliament was a Rajapaksa, but along with the president and the executive, the defense minister was his brother, Gotabia, and he was controlling the entire military, including information exchange and media. And the other brother, Basil, was economic minister, and he was controlling roughly all the resources of government, practically 90-something% of the budget. And with the Davina Ghuma bill, all projects that would come into Sri Lanka would eventually have to pass through him, because the provincial councils, which used to be autonomous, would now be all under him. So a lot of people were saying that this was inconsistent with the policy of devolution under the Sri Lankan constitution. The Bandaranaike court said that it was actually unconstitutional. But in the Sri Lankan constitution, if it's unconstitutional, you really can't say that it is unconstitutional, but you have to submit it to the vote of the people. So that's what they did, and it antagonized, of course, the Rajapaksa family because they won't be able to control all the resources as fast as they could. So an impeachment complaint was immediately filed against her. She was asking for additional time to file her answer, but this was not given to her. She denied the allegations in her letter asking for the extension, and she was saying that there really is nothing for me to deny in the absence of documents. But nevertheless, and then she went to the Court of Appeal to ask for an injunction, which referred the matter to the Supreme Court, which said, go ahead. The Court of Appeal has jurisdiction to issue an injunction against the violation of fundamental rights. But Parliament defied the injunction and proceeded to impeach her anyway. So the grounds for her impeachment is really unclear. They really did not discuss on whether she should be impeached. They just impeached her. So, oops, sorry. They both Chief Justices went to the Supreme Court to ask for relief, actually. Corona filed a petition for certiorari early on, but this was dismissed after he was removed from office on the ground that it was rendered moot by his acceptance of the decision. What is interesting about the decision was that it was very short and did not mention the Francisco Doctrine, which said that the Supreme Court has jurisdiction over anything that would probably have a violation of constitutional rights. In Bandaranaike's case, there was a complete turnaround with an earlier position. The court said that the Court of Appeal does not have any jurisdiction to supervise Parliament pursuant to the doctrine of parliamentary supremacy. So the Supreme Court reversed itself after the removal of Chief Justice Bandaranayake. So was there an application of the agency theory? In Corona's case, her successor in office was Lourdes Sereno. What is significant about her was that her dissenting opinion in Arroyo versus Department of Justice was extensively quoted in the impeachment complaint as one of the grounds for the allegation of bias for Arroyo, and her separate opinion in Hacienda Luisita, wherein she asked for wherein she recommended a higher compensation for the Coanco family. In Bandaranayake's case, Mohan Perez took her place. He was a former Attorney General. His court would eventually issue a decision allowing Rajapaksa to run anew for a third term, but he lost. So, what are my observations here? The role of political pluralism seemed to be very important. This is more glaring in the case of Sri Lanka than in the Philippines. Obviously, if all the power is in one family, that's practically just one family running one country. So it's an absolute monarchy in a sense. In the case of the Philippines, the allegations of bribery, I think, aside, what was significant was that the legislative was actually allied with the president and there was no strong opposition. Corona's impeachment should not actually be taken in isolation because Corona wasn't the only one that Aquino tried to remove. Before Corona, there was the ombudswoman. And before the ombudswoman, there were the other appointees to ordinary government offices during the ban. So it wasn't really just against Corona, but it was actually against everyone who was appointed by Arroyo. There is a lack of due process. In the Philippines, there were creative ways of doing it, like the little lady and the mysterious messenger, as an excuse for the spurious documents. And we also have Sri Lanka, wherein there was really just no due process. Obviously, no due process because she was just impeached. There's also the absence of effective domestic mechanisms for redress. They both filed actions in the Supreme Court, but neither Supreme Court was able to give an effective relief, and they just conveniently actually dismissed the petitions without really explaining why. And this gives ground for the chilling effect on the court, but I would think that this is insufficient insofar as saying that impeachment really has a chilling effect on the court, because we also have to assess whether the courts would actually have been ruling this way even before the impeachment, or was there really a direct relationship between the impeachment and the decisions after the impeachment. So my proposed course of action is international intervention and treaty obligation. As I mentioned earlier, judicial accountability is still largely a gray area outside of the United States. In the US, it's fairly defined, but it's a bit more different because the US has various systems of recruitment into the judiciary which are not found outside, such as the election system. And I think that there is also a need for a system of benchmark in the conduct of trial, because as you can see in Sri Lanka, there wasn't even a real trial. There should be, to come up with these benchmarks, I think that there should be an identification of best state practices. So a survey of other jurisdictions with respect to their rules, and to resolve the question of independent review. Is independent review proper, and who would actually conduct the independent review? So I asked for Professor Reyes's permission to discuss the methodology and of how I would study this, how I would study the matter. So my methodology basically is comparative. So it has two components. The first one is constitutional ethnography, which is concerned with the development of the legal norms within a particular jurisdiction and the precedent tracing approach to see the stability of legal doctrines. So basically, what I want to do is to see the interplay between how the court exercises its power and how it exerts its power outside of the court, and how the political structure of the society actually affects the court. So for these, I'm studying particularly the selection, nomination, and appointment of judges into the courts. And so there's the impeachment. So how does it actually affect the composition of the court, and whether the composition of the court would have an effect on the decision-making process and the judicialization of politics. The large box stands for media, because media has become a very strong force in society, such that media can actually alter public opinion with the way it frames information and opinions. So I think it's necessary in this case. So how are the rights of the justices protected? So again, I would be surveying the rules on the conduct of the impeachment proceedings, with particular interest to the procedural safeguards and availability of effective mechanisms of redress and external forces. So I leave you with this question. I was also trying to find materials on Sri Lanka and the Philippines to support the trial, but obviously there was no trial in Sri Lanka. I couldn't really find any material. So I want to show you, this is the primer created by somebody against Corona. So here, it's basically his career, the duties of the chief, what is a chief justice, the procedure, and here, this is the midnight city pertaining to the midnight appointment. And then they were quoting experts to say, who were saying why he was a midnight appointment. Yeah, it's fairly long, so I couldn't show everything. But I also have a video. So this is a video that came out afterwards. So, but they had something like this during the impeachment, pointing to his, well, guilt. So I'll just play it. But most of it is in Filipino, but I think you would understand the actions anyway. So that ends my presentation. I'll just continue playing the video.
How long is it?
It's 7 minutes.
7 minutes. I think they prefer to ask. You can always give them a link to the video. I think they prefer to ask some questions and have some interaction with views. Or we can play it silently in the background.
I'll just play it silently.
But perhaps you'd like to raise some questions, make some comments, etc.
Oh,
Yes,
yeah.
Artemi.
And I was wondering whether or not the right to fair trial will play a certain role there. I believe it's protected under ICCPR. So whether or not the judges in the process of impeachment would be entitled as human beings to the right to a fair trial, and whether or not it can be one of the safeguards in the impeachment procedures.
Well, it actually should apply to them, but the problem is it's rarely applied to them, especially if it's decisional independence, when they know that their case is weak. As I mentioned earlier, they find creative ways of going through the process, going around circles to avoid giving the justices these rights. But they do try, like in Malaysia, the Lord President didn't participate in the trial because it was held in secrecy. And then they said that, well, he didn't come, so he waived his right to fair trial.
Does that really address the question? Obviously, the judge, like any other human being, is entitled to certain rights of due process. The question is, does it really matter what you're really talking about, most examples that you've given, is a political process where the judge has got to go anyway. That's the end goal. So whatever the judge says by way of rights or so on, there'll be a show trial possibly, maybe it's not even going to be a trial. The judge will be expelled at the end of the day, because that's the whole logic of having the impeachment process. So is there really going to be any sort of protection if you're going to have a political process where the judge has got to go because the judge is inconvenient to the plans of the executive? Then whatever you want to say, whatever rights you hold up, the judge is going to go. There's really no, the problem, it has nothing to do with rights. The problem has to do with the structure of the society.
Yeah, it's more of the structure and the enforcement. So that was why I was proposing that. I was thinking that you would have to go international, because unless and until the regime steps out of, or it topples, or whatever happens to it, then you cannot find any redress within the domestic sphere. But even if you go international, there may be an instance such that they would actually say that there was a violation of fundamental rights and order everything. But if you come back, then you go back to the municipal courts to have it recognized or something. But if the regime still does not want to respect it, theoretically, there's nothing to do. The rights will be there. It's a matter of enforcing those rights in the domestic realm.
But let's press you a little bit there. What do you mean by going international? What does it mean by going international? This is not a matter for the United Nations. The United Nations is not going to interfere on this. There's no such body like PEN for writers or journalists or so on. There's no such organization for judges. So what do you mean? It's all very well to say go international, but what do you mean?
In Peru, at least, in all these cases, Asia does not have any regional mechanism. So we can see Malaysia, the Philippines, and Sri Lanka. There's no mechanism unless you go to the Human Rights Committee and say that there was a violation of your rights. In Peru, it was easier, I think, for them to go to the Inter-American Court of Human Rights to ask for an opinion on whether their rights were violated. So I think if there's some international mechanism, it would be better. But whether or not it would be recognized in the domestic sphere is another case.
So is it any effective solution to say go international? It doesn't seem to. It doesn't seem to be anything more than suggest that well, you can try to have an international campaign for the rehabilitation of the judge, but in practical terms, there's nothing really one can do.
Yeah, that was exactly my discussion with Kelly on the solution that I was presenting, which is to go international and to elevate it even to a treaty obligation. But the question is whether it's really going to work, whether there would be really relief given to these judges, or would they just have to wait until the next regime and see if they would be recognized for their efforts.
Which is what happened with Chief Justice Bandaranaike. She was reinstated by the new government after Rajapaksa lost the election. She was reinstated, and after one day on the job, she resigned, and now you have Chief Justice Sri Pavan there. Mohan Pires had to be, well, he stayed in office. He refused to go until he was escorted out of the, so that was Mohan Pires.
The same thing happened actually in Peru. Even before the International American Court of Human Rights said that they should be reinstated, Congress actually recognized that they were wrongly impeached and asked for their reinstatement. So, but if it's going to be a political solution, then how about the human rights of these judges? And then it's very difficult for somebody to go against the regime if there is nothing about him, if he can't find any solution to the violation of his rights. So
right.
I'm actually...
Professor Davis.
Yeah, I think, isn't it true generally in many regimes in the world that human rights aren't so rigidly protected, that people really don't have access, whether they're judges or not. And I sort of understood when you said go international from your presentation, then you talk about benchmarks, that you were more talking about trying to come up with international standards of behavior, rather than that this judge would be able to appeal to an international tribunal. Now, in the context of Europe, we know in Hungary and several countries, and now there's some recourse in Poland regarding, attempts to put pressure on judges and the constitutional courts in these European countries. And the European Union, the European Court of Human Rights, and the EU both have fairly high access to, and there's been orders in the case of Hungary where Orban, the leader there, tried to get the court dismissed. There are orders that have protected the court. So that is one form of going international, but I think a lot of times in many other parts of the world, as you mentioned in Asia, where there's not a regional human rights treaty, that your version of going international would be something more like identifying benchmarks and guidelines, things like the Paris Principles and other things that we use a lot in public debate. And this becomes a kind of tool in the hands, political hands, of people on the ground in the country who are resisting what the government's trying to do. So I think that's part of the going international side of your argument, that maybe has some traction, and where the rest of the idea that some outside tribunal, and at least in Asia, is going to tell them, order them to do anything, is probably a very remote possibility. So that's one side of it. And I think another problem for your whole project, of course, is that constitutional judicial review is political. I mean, the courts themselves are political. Appointees look at the United States now, where one appointment is being held up over politics. So I think the Alex Bickel forward, which I know you read in a class that I conducted a few years ago for you, that this is sort of accepted, that the creation of a constitutional court, whether it be identified as a constitutional court or just the highest court, is itself very political, how people are appointed to the court and so on. And some jurisdictions do a little better at hiving it off and having judicial selection commissions, although recently in India, where they tried to do that constitutionally, create a judicial selection commission, the court itself slammed it and held it to be unconstitutional, requiring that the judges themselves have the power under the Constitution to appoint members of their court. So even there, it's very political on the inbound side, and then the decisions they make are political. I don't know whether it's judicialization of politics or politicization of the judiciary that we're talking about here. But maybe if that's all true, then, and this agency theory you have says that, well, in some ways the court can't be completely off the track from people in power, that somehow it's part of the system. So maybe your effort has to be somehow to find out how to accommodate that politics, not sort of to get away from it, that it's just inherent in the nature, not of every judicial appointment, of ordinary judges in the system. Most systems try to come up with less political ways to do that. But the highest court that exercises constitutional review typically is very political. In France, in fact, they created a constitutional council because they don't trust having ordinary judges do this. And so this idea at first was just to review ahead of laws, pre-promulgation. So there are moves that some countries make to allow this, for this politics. I think, I'm not sure what all the answers are, but I think the idea that you're going to pull it out of politics doesn't sound too likely for this highest court. So benchmark idea, I think, is good, sort of creating standards by which people engaged in politics can make their case, which what we do all the time, right, as human rights lawyers. So that I think has some promise. And of course, the idea that an outside body can evaluate what governments are doing, as they do in Europe, may be a long-term goal, but we're so far from that here in Asia.
So I might invite Gladys to make some comments. I believe Gladys has sat on the York
Yes. Yes.
Are you still sitting on?
No,
on
no,
the-
no, I haven't.
Which is the judicial officer's recommendation commission.
Right.
The committee that makes recommendations for appointment, amongst others, to Chief Justice
Right.
here in Hong Kong. So Gladys actually has personal experience in the selection of judges and the evaluation of judges in a way that is impartial. Perhaps you'd like to make some comments.
Well, yes, certainly. I think, first of all, impeachment as a process seems to me to be inherently political. And whereas one might just about justify it in the context of politicians and a political process, I think it's fundamentally different with judges. I mean, if you recognize the importance of the judiciary as a branch that actually acts as a check and balance and is also has a primary role in the defense of rights of ordinary citizens, then I think that the process of, quote, impeaching a judge requires to be as standardized as possible to take out the political element insofar as you can. But first of all, you have to look at how judges are appointed, because it seems to me if you always regard the Chief Justice and judicial appointments as a substantive function of the executive, and actually I always appoint the people who support me, you're inevitably politicizing the judiciary and bringing with it the potential for impeachment when the regime changes. So if you don't also do your best to institutionalize the appointment of judges and try to remove the political element from that, it seems to me you're always going to have this problem of impeachment of judges being highly political and actually depending on who is in power at the time. So really, I think you need to look at these processes in terms of why do we have such a thing even as impeachment of judges, and what is judicial accountability, and not looking at it from a political point of view and recognizing the special role of the judiciary and maybe having an apolitical, as far as you can, appointment system.
So that Professor Davis has suggested that a benchmark system, what you could do in your PhD research is to develop principles of process for removal of judges. And I think Gladys makes an additional point in that you can't just look at the process of removing a judge. You've also got to look at the process of appointing a judge, because the two go hand in hand. And if the process of appointing the judge is really the gift of the executive, then you're not going to have an impartial system. You've got to look at both components, how the judges become judges and how judges are removed as judges, if you're going to have a truly credible system. I think that's the suggestion being made.
Yeah, this is one area where I think the U.S. influence has been bad in a way, because I admire what we have here in Hong Kong, and I admired the effort in India to protect the appointment process for judges very much over the last fall. It was very much in the news worldwide. But the U.S. model is rather political. It ultimately, for federal judges, the president nominates and the Senate approves. It couldn't be more political than that. There's some idea that you consult the bar and stuff on this, but when we had a Republican president, he was more interested in consulting the Federalist Society than the bar, which was more right-wing. So it's, I think in the Philippines, I imagine the influence of that U.S. model is probably there. And
they removed the Commission on Appointments after
Yes.
the president, but the Commission on Appointment appoints the the president appoints the members of the Judicial and Bar Council with the concurrence of the Commission on Appointment, so it's indirect.
yeah.
Perhaps while we're at it, and since we've got someone from Russia, perhaps he can give some comments on how the Russian judges, or in fact the top judges in Russia, are appointed.
Well, they're appointed by executive. So generally,
When you say the executive, who? The Prime Minister or the President or
it
the Duma?
depends. like on the lower level, we have the Judiciary Association, and none of the people who actually work there are judges, but they're like qualified lawyers who select judges. Usually, generally, because it's Russia, everything is kind of like decided, you know, on like those meetings for a few people, and they're like, this guy looks good.
Let's go to the highest. That's at the local level. Let's go to the highest levels.
I assume like there's like good
You assume,
guy.
so we're not sure.
I'm not sure, but we have constitutional courts. It's pretty political. Like, for example, recently we decided that we will not enforce ECTHR decisions, like European Court of Human Rights decisions. And we kind of actually followed the UK there a little bit, because also UK played a major role, because they're now not enforcing many decisions in terms of prisoners' rights. So how Constitutional Court works, a judge is appointed, I think, for 20 years.
By whom?
So there are like several steps. I think the president nominates a candidate, then Ghuma approves the candidate, and this is pretty much the process. So there's like there's always, usually in all judges, there's someone should like recommend judges, like make a reference, and then legislative body approve the candidature. Removal process happens really rarely because they all pre-selected, so we don't really have this issue of like a confrontation, because people just know who will be the judge.
They never had an opposition government.
So, yeah, like,
I think this brings home what Gladys has said. You also got to look at the appointment process. It's very important. We just can't look at the removal process.
Actually,
Now, I was just, as I told you, I was just in Russia yesterday at the St. Petersburg Legal Forum. And one of the themes of the forum this year is trust in the law. And one of the points that was made by Minister of Justice, Konovalov, was that Russia is changing, that there is movement towards getting, applying international standards of the rule of law to an even higher standards, let's say, he suggested, than what's being done in Europe. How would you say, what changes do you see in the system, if any, that might be gradually moving towards a more a judiciary that is more independent of the executive?
it really depends. Like, there's a judiciary independence in terms of public law and in terms of like tort law, private law, and so on and so forth. In terms of commercial law, judiciary is fairly independent. I mean, of course, there are some cases of corruption, but in most of the cases, judges are pretty impartial.
Well, we see that in the recent amendment of the arbitration law. In September of this year, there will be a new arbitration law in order to ensure that international commercial arbitration is how do you say, dealt with impartially, and arbitral awards are enforced in Russia. So that's part of the movement that we've seen. What about in public law?
In public law, it's always more complicated because there's a lot of political interest. For example, like on the lower system, you actually can find a position not on the top, but sometimes at the bottom. And there's a case in my republic when few judges dissent on the terms of public issue of government spendings. They all got dismissed, like 3 of them within a month, and replaced. So that's the problem. In terms of public law, I don't really see a lot of progress, because people are still very conservative and the political system is very conservative. So if you really want to change the system, it's pretty hard. It's not in terms of the law. Like the human rights movement, I think in Russia, it was never really like a law movement. It was more of a political movement. Even like with people like Navalny, I mean, they go to court, but rarely, because everybody know like how court will end up. Like higher official will say something, Putin will say something, it will be like this, and everybody knows this. So in terms of really pluralism or the struggle for human rights, I wouldn't go to courts. I wouldn't say that they're effective nor impartial.
Now, Professor Davis.
Just on this, I think we should bear in mind that right after the sort of breakdown of communism under Yeltsin and others, there was a Chief Justice named Sorkin who was very activist. He would go out and try to mediate between the branches of government over conflict and so on. And he was a classic case of overreaching by the court, and eventually they get rid of him, but I think the consequence was that they trimmed the wings of constitutional review there. So the court its powers are much diminished from what this earlier attempt under that constitution was. So I think there's a kind of memory within that system now and a bit of concern about having too active a judiciary. And I think that makes it so you don't see these kinds of things that Angela has been describing.
But perhaps I might go back to Angela and ask her, not all societies are societies where you have a perfect rule of law. In some societies there are, you have more, some societies you have less of a rule of law. Some societies you have are close to, or one might describe as dictatorships. If you're a judge in such a society, if you're a chief justice in such a society, what is the point of sticking out and going against the system? You'll simply be removed by the politics of the system. Don't you think it would be better for a judge in such a system to try to do the best that one can? You may have to accommodate the ruling powers in certain respects, but in order to do as much good as you can for the ordinary citizen in other, perhaps less political aspects. So the role of a chief justice may differ in particular societies. We talk about judicial accountability and judicial independence, and that's not always easy in certain types of societies, so that there the judge's role may be to, use the expression that Professor Davis used, mediate in a quiet way between the powers that be and the ordinary citizen. So try to get the best deal that one can, but not rock the boat politically. How would you react to that?
Do I answer using my dissertation, or?
As you wish.
Okay. I think at some point the reality is really you have to ride with a trend of politics. And sometimes it might be better to actually work with them rather than against them, to be able to afford protection, at least in some ways. It's better to have a little than none at all. So I would think that there would still be some areas that the court really cannot touch upon, and that would be a restriction on judicial independence. But the goal is just not to be too politicized and still be able to exercise independence in certain areas and uphold the rule of law.
If that is the role of the judge, might it be suggested that really Corona misjudged the situation? What he should have done is, I mean, who wants to be Chief Justice, to be frank? Who wants to be a judge? If people say, we want to impeach you because you were a midnight appointment, Corona says, well, I took on this burden, but if I'm not wanted, I will go. Why stay on? Isn't that really his, shall we say, his tragedy, the one fault, the one error that he made when he said, I will stubbornly stick on? He said, well, you don't want me. I don't want to be Chief Justice. Who wants to have this office? Who wants to wear this heavy, heavy burden? I will step down.
That's actually a question we wanted to ask, but he died.
No.
May I?
Yes.
Okay.
Sorry. In the time of Marcos, the question of whether the Supreme Court should resolve political question was also raised, and this was in the Haveliana case. And the Supreme Court took the prudent way and decided that all political acts should not be subject to judicial review. And for that particular decision, the court has been accused of perpetuating the dictatorship of Marcos. When Corona took the appointment as Chief Justice, he knew from the very start that he would be impeached. And his reason for sticking to the job and for taking the appointment and defending his position was a symbolic act of preserving the independence of the court. To the very end, he was asserting that the judiciary should be independent from the executive. At that time, there was already this concept of a hyper president where you have the executive just capturing both the judicial and the legislative branches of government, and his role there was to just assert the independence of the court.
Now, he was not the first choice, was he?
He was.
It went to several people. They refused it before it came to him. He was
He
the
really
most
was.
senior at the
He
time.
was actually,
He was,
He was-
the only.
the side story, the really side story was that he was actually in Valenzuela and Vallarta. He was the list of 3 for the Court of Appeals.
He was, in fact,
Had-
before the appointment of the more senior to him, he was the one to
He
be
actually
appointed.
was appointed to the judiciary early on. But if you look at Garfield now, that actually belies the fact that he got an appointment early on during the Arroyo administration, but he was snowpaked. So his name was erased. And then it was changed to another one. And so he had to wait several years for his own appointment.
Right? Any other questions?
Just a comment
Professor
on
Davis.
what you said about how the court has to accommodate reality. If I recall correctly, there's actually a doctrine on this in the face of coup d'etats, that a court it's accepted, that a court can go along with the new regime.
The new Grundnorm.
Yeah, that's right, that in fact, the accomplishment of the coup d'etat itself legitimates the court sort of, wincing and going forward under the new regime rather than insisting that the new regime is illegitimate under the Constitution. So,
And didn't we have something sort of comparable in the Provisional Legislative Council, the court's decision on that?
right,
I mean,
right.
you know, at the end of the day, whatever the quote legal answer, right, there it was, the Provisional Legislature.
Well,
So,
I think Professor Henry Wade has a similar theory, except he applies it to 1688, the Glorious Revolution. There's a new Grundnorm, and then whatever the judiciary, all the instruments of government at that time simply accepted that, and therefore it becomes the new Grundnorm. So
Right.
that's the new revolutionary Grundnorm of 1688.
Can I raise just a technical question?
Yes.
Point. There's actually 2 processes involved. The first is an impeachment process, and the other is a trial process. And I think those 2 should not be confused. The impeachment process under our Constitution is essentially political. Even just one affidavit of one congressperson and one citizen can cause the impeachment complaint to be brought to the Senate. But that's essentially really just political. But when you come to the trial aspect, there really ought to be some benchmark. And
So are you suggesting there can't be a benchmark set of principles for what you call the impeachment process?
there are some rules there which are principally procedural.
Well, no. That's
But
not an
whereas
answer
for
to
the
my question.
trial-
Are you saying that that you can't have benchmark principles for the impeachment process?
Yes.
Because
Because
that's
it's really
political.
just, you know, even just a letter can cause the impeachment of a.
So you don't have to have due process in impeachment. It's
But
due
in the
process in
trial
trial,
aspect, because essentially you have a trial.
right? I think Angela asked to be released or to be confirmed.
My paper for confirmation.
Confirmation.
Can I submit my paper for confirmation on the 31st?
I'm sure you can.
Can I?
I'm sure you can.
I actually don't know who's gonna sign, you or you.
Well, you want me to sign? You want Professor Davis to sign? He'll sign.
Yeah, we'll sign, we signed, we're professors, you just put papers in front of us.
You are the author of your own meeting making. All right, we'll thank Angela for an interesting and stimulating discussion. If you'd like to discuss with her further, she's around, subject to her confirmation.